Hi there, good afternoon everyone. Very warm welcome to this afternoon's construction and engineering webinar, and thank you very much for joining us. This is our spring update for members of the Chartered Institution of Civil Engineering Surveyors. My name's Stephen Harris-Wright. I'm a partner in the construction and engineering team at Burkitt Solicitors. Just a quick thank you to the CICES for inviting us to present to you again this afternoon. Regular viewers amongst you will know that we've done quite a few of these sessions for the membership over the years. We're always very happy to do those and grateful to be asked back as well. So, just briefly then, I'm going to be joined this afternoon by three of the colleagues from our construction team. They are up on the slide for you here: George Elliman, Patrick Cooney, and Stephen Williams. So hopefully most of you will have heard of Burkitt's before, and I won't give you the hard sell, but just in case you haven't come across us previously, there's a bit of information for you up on the slide here. Just in summary, we're a full service top 50 UK law firm. We've got 7 offices across the UK, in the east of England, London, Kent and Bristol. And as part of our organisation, we've got a specialist construction and engineering team that deals with advising on sort of transactional, non-contentious matters, but also the back end of projects when they get a bit more sticky, dealing with contentious construction issues as well. So, in terms of a brief summary as to what we're going to be covering off in this afternoon's session, George is going to be talking about reusing materials in construction projects and focusing on risks, liabilities, and best practice in that area. Patrick's going to give a brief overview of key events from a construction legal standpoint in 2024. It was a pretty busy year, so quite a lot to unpack there. And then we'll finish off in terms of the sort of substantive parts of the session with our traditional final piece, which is an update from Stephen on some interesting recent construction and engineering cases. And then we'll have some time at the end, 10 to 15 minutes or so for a Q&A. So just before we get into the meat of the session, I've got a bit of sort of housekeeping just to quickly run through. There's an opportunity for you to put your questions through to our panel using the questions function in the Teams portal. So please don't be shy, that the questions come through to us anonymously, and we're always keen to hear from you, help make the session a little bit more sort of lively and interactive, as it were, sort of in the Q&A at the end. We've had a great turnout for the session in terms of numbers, which is fantastic, and we'll do our best to get through as many questions as we can, and then I'll look to draw proceedings to a close by 1:30. So last thing from me before I hand over is just to say that the session is being recorded and will be circulated to members and attendees along with a copy of the slides in due course. Right, okay, that's it from me for now in terms of an introduction. I will hand you over to George for the main first part.
Thank you, Stefan, and thank you everyone for joining us today. So we've decided to talk about reuse of materials on this webinar in particular because of the quite significant movement over the last few years in the construction industry towards more sustainable forms of construction, and thinking about how that new approach interplays with some of the assumptions, some of the status quos in contract drafting, and other considerations that might mean a bit of extra thought needs to be given to contracts, to projects, and how those liabilities are divvied up between the parties. So starting with a bit of a basic and very quick summary of sustainable construction and reuse of materials generally. It's very important for meeting our net zero goals that the construction industry moves more towards this type of construction. As we all know, there is a significant carbon cost in constructing buildings. Some of that is the operational side once the buildings are active between start of use and end of use. But a large part of it is in embodied carbon. So that's the carbon that's expended in the process of procuring and constructing a building. And a large part of that embodied carbon is in the use of materials, the types of materials we're using. So the production of steel, the production of cement, the production of glass, etc. So the incentives and the priorities to increase the efficiency and sustainability of those materials being used is becoming more of a priority for the construction industry, and controlling that waste both at the start, as in what materials are we using, and at the end of life, are we building for traditional demolition, or are we going to try and build to deconstruct this building where certain parts might have utility even when the building itself has ceased to. And that is drawn out very much in client priorities around buildings. You will often see these days certain environmental standards will be referred to expressly in contracts or within the contract documents and in tenders to meet certain requirements, things like the BREEAM standards. You also have the Net Zero Building Standard, and other industry documents and guidance are increasingly starting to draw this part of construction out. So you have things like the BCO Fit Out Guide, which expressly refers to reuse of materials as being critical to delivery of net zero targets. But with that, you also have the distinct risks of reuse. So there's a certain lack of product warranties and guarantees. There's a bit of an uncertainty over the remaining design life, although that's going to vary project to project. It's going to vary material to material, exactly how much you can predict how much design life is left in a material. You also have other issues there with traceability, with insurance, although again, that is improving as it's becoming a bit more common. So with that in mind, a quick recap on implied design liabilities under statute and common law. So these are the types of obligations and duties that will arise when a contract doesn't deal with this expressly in a different way. So you have an implied contractual duty there that when a person holds themselves out as a designer, they'll exercise reasonable skill and care. You also have an assumption that the products of the design and the goods and materials used are going to be fit for the agreed or known purpose. And then you have an obligation that the materials are of good and proper quality. So it's fairly well known now that a fitness for purpose obligation is considered the most onerous of these implied duties. The distinction between reasonable skill and care and fitness for purpose is ultimately a sort of behavioral one. How much agency is there on the person subject to that standard to improve its position or control the outcome? When you have a situation involving reasonable skill or care, there's room there for interpretation. There's room there for a designer to say, yes, this went wrong, but here is how I met the reasonable skill and care obligation. With a fitness for purpose obligation, or something like you will meet a design life for this many years, or you will meet this exact product specification, this is more of an absolute obligation. And there's less room there for behavioral factors. It's more about, did it fail? Full stop. And fitness for purpose does come into the most recent versions of the JCT design and build contract, which is what we're using as a standard form contract example here. This is a summary of how the JCT design and build contract deals with these kinds of duties. So 2.1.1, you have this obligation that when you're completing the design for the works, the kinds and standards of materials, goods, and workmanship will be the responsibility of the design and build contractor so far as they're not described in the employer's requirements or the contractor's proposals. At 2.1.5, you have a new clause, which was previously a slightly different wording, a supplemental provision, an optional provision, that you can suggest improvements in the environmental performance and sustainability of a building. And then 2.17 deals with design specifically. So there's an obligation to use reasonable skill and care in such design, and then at the follow-up clause, an exclusion of that more onerous fitness for purpose obligation. And the important point to note about these is that these are very, very frequently amended in clients' template building contracts or in the course of negotiation around particular design risks. So it's very, very common to see that standard of care, that reasonable skill and care, expanded to a greater level of duty. You'll see words like diligence brought in as well as skill and care. You'll often see the hypothetical designer who you're reaching the same standard as will be more specified around the value of the project, the scope of the project, the complexity of the project. You'll also regularly see the exclusion of fitness for purpose obligations removed, and that effectively because of the implied right, depending on what is in the project specification, the contract documents, may mean that there is a fitness for purpose obligation to meet certain specifications. You'll also regularly see a transfer of responsibility for design in the employer's requirements onto a design and build contractor, effectively giving a full package of design liability on a single party. And finally, you will often see stipulations on material use being included in a contract, going beyond the standard quality requirements. You may even see a requirement for all materials to be new. Now, obviously, if you have a clause like that within a contract, if it's a historic clause that just hasn't been removed, and this is a project where there is going to be a significant amount of reused materials or an intention to use reused materials, there's one part where you immediately have a contradiction in the contract terms with the intent of the parties for what is actually being built. And a really good case to look at around how absolute obligations in a specification can really run up against the implied duties or the contractual duties of care is the MT Højgaard case. So this was a case from a few years ago that reached the Supreme Court. It was around the construction of 2 offshore wind farms and a structural defect in the foundations of those wind farms that resulted in the failure of the foundations shortly after completion. And that failure arose from an inconsistency between 2 technical requirements in the tender. So there was a requirement to meet a prescribed design, which was J101, and there was also a requirement to reach a design lifetime of 20 years without planned replacement. So this is effectively a fitness for purpose obligation. It's saying that here is the exact specification we require, and here is what you'll need to meet. So these requirements were ultimately inconsistent, and it was not possible to meet both. And the case centered around who is responsible for rectification costs. And the Supreme Court view was that instead of releasing MT Højgaard from liability, the correct analysis was that the more demanding of the requirements had to prevail, as the less rigorous could be treated as a minimum requirement. And they concluded that if there is an inconsistency between the design requirement and the required criteria, although it may have complied with the design requirement, MTH would be liable for the failure to comply with the required criteria, as it was MTH's duty to identify the need to improve the design accordingly. So this is an onerous obligation on Højgaard. They've lost at the Supreme Court. It would have been very expensive for them. But it's a useful case to think about when we look at reused materials and the potential design lifetime concerns there are around reused materials. What is included in the specification and what is in the contract or is the duty a contractor or a designer thinks they are working to could be different. So thinking about a working example, let's say we have a project now that requires the contractor or the designer to meet a certain certification for environmental performance. They may have to procure a proportion of construction materials from reclaimed sources, but they also may need to meet a performance specification or a design life of a fixed number of years. Now, if that contract does not exclude the designer's implied fitness for purpose obligations, then that would create an elevated risk to the designer. they would be simultaneously having to source certain amounts of materials from reclaimed sources, meet environmental specifications, but at the same time, those materials may run into an issue with design lifetime and the fitness for purpose obligation. And just a reminder there about what the Supreme Court concluded in Højgaard, they would be liable for the failure to comply with the required criteria, as it was their duty to improve on the design accordingly. So to finish up with some key takeaways, really the key here is around consistency between legal terms and consistency with specifications. So thinking about template contracts, whether they're client-side template contracts or your own template contracts, think about if any terms in there are not appropriate for the kind of project we're working on. So if you're planning to use a lot of recycled building materials, think about if any of those clauses are inappropriate. So anything stipulating that materials should be new. And to avoid the same trap they fell into at Højgaard, specifications should always be clear and consistent. Design requirements should be clear as well. And you want to avoid a situation where you have two competing requirements, of which the more onerous one is likely to be taken as the one to meet. And finally, aligning technical contract documents with the contract itself is important. You want to look at it in the round and think, is this all appropriate for the kind of project we're working on? So it's an interesting one. It's going to become more important as we move forward, as reuse and recycling materials is going to become more prevalent. The industry will settle into new norms, new drafting approaches. It'll be interesting to see. But that's it from me, and I will pass on now to Patrick.
Thank you, George. I'm going to have a look at some of the key points from 2024. As Steph mentioned at the beginning, it was a busy year for construction. So I'm just going to spend 10 minutes looking at a few sort of key takeaways. Now, before you all leave the room and say, not another talk on the Building Safety Act, I don't think we could look at 2024, the last 12-month period, without mentioning a few key concepts. The Act came in 2022, but provisions are still coming into force, and much is obviously still being written about it, and particularly in the wake of Grenfell. So I wanted to just have a recap of some key concepts that the Act brought in. So the duty holder regime is a key element of the Act. Legal responsibilities were introduced on those who commission building work clients and all of those involved in the design and construction process. The competency requirement has also been written about extensively. Everyone doing work in connection with a building, whether that be physical works or design, must demonstrate their competence and do the work in a way which complies with the building regulations. Now, how competency is demonstrated is quite another matter, and we could probably have an entire webinar on that, but that's the overarching requirement. We saw the introduction of a building safety regulator. So the regulator is part of the HSE, a sort of an overseeing role to oversee the safety and performance of all buildings. So the regulator advises on emerging risks and possible changes to the regulations, so that the regulations and the requirements are current and constantly updated. And in particular, it's the regulator who enforces breaches of the Act, and significantly that can now include criminal prosecutions. A great focus of the Building Safety Act is the is the regime for higher risk buildings, HRBs. Many of the more onerous requirements of the Act apply to HRBs only. There's a note on the slide there as to what the definition is. So an HRB is a building which is 18 meters high or 7 stories high with at least 2 residential units. And any care home or hospital will automatically be an HRB. You may have read about the golden thread concept. That's all in connection with the HRB regime. So it's a duty to maintain that core thread of documents and information about a building, about how it was designed, how it was constructed, and a thread of information which can be trusted and shared and relied upon, so that essentially it's the safety elements can be fully understood. And the gateway process is part of the HRB regime, points at which duty holders must be able to demonstrate compliance with all of the BSA requirements at the various stages of the building control process before moving on to the next stage. And on the litigation side, we saw the introduction of building liability orders. So no longer can developers or any entities hide behind special purpose vehicles or shell companies, or can any company run the insolvency argument? You know, there's no point coming after us. If you do, we'll just go bust. The corporate veil, as it's sometimes referred to. So the court can now look behind that. The court can look into the corporate structure and can issue a building liability order against, not the contracting entity, which may be the party at fault, but an associated or connected company that's part of the group. The parent would be an obvious example, the one that's holding all the assets and the money, but isn't necessarily the one that committed the breaches. Wherever it's just and equitable to do that, the court can do that. And that's quite relevant to a 2024 update, because last year we saw the first example of the High Court using this power. That was a very rapid run through of some key concepts. The next topic I wanted to cover, again in very much an overview, is the JCT 24 updates. Not a radical overhaul, quite iterative, but I'm just going to recap on the main ones. There's a new Article 3, all about working together in a cooperative and collaborative manner, good faith and spirit of trust and respect. The keen-eyed amongst you will notice that that's very NEC-like in terms of its wording. And I think the NEC would say the JCT are a bit late to the party in terms of introducing these sorts of concepts. I mean, from a legal perspective, it's the sort of thing that's quite difficult to enforce. Breach of trust and confidence, good faith, quite nebulous concepts, but really that's not the point of these sorts of obligations. The point of them is to change behaviours and encourage a collaborative mindset from the start. George mentioned the sustainability and environmental impact clauses in the JCT now. As George mentioned, they're not new. They used to be in the supplemental provisions, and they've been brought up into the sort of main conditions, so they'll apply in every contract. Very little on the BSA. The JCT has done very little on the BSA. There are entries in the contract particulars for who the building regs, the principal contractor and designer are. There's a fairly brief obligation on the employer to share building information with the contractor. Part of that sort of golden thread type concept, but not necessarily in relation to HRBs, but very little really on the BSA. There's nothing to do with the HRB regime. So the JCT sort of dodged that a bit, I think, and if you are dealing with an HRB, you'd need to think about some bespoke amendments to sort of specifically flow down all of the relevant requirements there. And then again, picking on up on one of the points that George made, there was a very specific response to that Hogarth case, which makes it clear that under no circumstances shall the contractor be liable for a fitness for purpose obligation. So underlining that skill and care is the relevant test. An epidemic is now a relevant event, so something which entitles the contractor to claim more time. And the existing relevant event around change of law now includes the publication of guidance. Yeah, obviously both a response to COVID, and the issue with the publication of guidance was, at the time of COVID, it wasn't actually a change in law which required us all to stay at home and change the way everyone worked for 2 years. It was actually government guidance, so the JCTs expanded to encompass that. And those things can be relevant matters, but only if they are specifically identified as such in the contract particulars. So there's an option to sort of switch them on as relevant matters, things which entitle the contractor to claim more or more money. So the default position is they'd be cost neutral, but you can switch them on. Again, a response to case law on the slides there in regard to LADs. So a clear statement that LADs no longer apply, or not that they no longer apply, they no longer accrue if a contract is terminated. So they stop accruing at the point of termination. And from there on, it's not that you're not entitled to any damages, but they're general damages, not the sort of liquidated damages at so many per week. You'd have to prove your loss for lateness after that point. And again, that's a response to a specific case. That was a very rapid run through of the 24 changes, but as I say, they're not. They were quite iterative and not a radical overhaul. We saw the introduction of the final report, the final Grenfell report. Now, the phase 1 report was published in 2019. So, but only last year in September was the phase 2 report published. 1,700 pages and 58 recommendations. Whilst the first report looked at what happened on the night in question alone, the second phase 2 report, or the final report, looked at the wider circumstances and causes. I've lifted out a few of the key recommendations there. One of them was a single regulator for the entire industry, so a much wider remit than the building safety regulator, to drive change, certify products, potentially license contractors to work on HRBs. That's something that was recommended. New statutory requirements for building control approval. This would be quite an onerous requirement on the PD and the principal designer and contractor for the building regs. There's a recommendation that those individuals, effectively, or senior representatives from the relevant companies, give statements that all necessary measures have been taken to ensure that the building is safe and compliant in accordance with the Building Safety Act's requirements. Obviously, huge scrutiny on fire engineers. Recommendation that a separate regulatory body is set up, which doesn't exist at the moment. New testing measures for assessing conformity of actual construction products, which was obviously a huge issue in the fire itself. And suggestion that the approved, or recommendation that the approved documents should be updated with input from academics and those with practical industry experience. Now, in terms of the other findings in the report, there were some quite damning findings for the industry and, well, the firms involved, and for the government. Some very clear and strong language used. The government was government departments were described as having a complacent, defensive or dismissive attitude to fire safety matters. The architect was said to have a very significant degree of responsibility for the fire, for consistently falling short of the standard of care, to pick up on one of George's points, and not recognizing the dangers of installing combustible cladding. Particular dishonesty from the head of the technical sales team, which sold the actual panels. He engaged in deliberate dishonesty on learning that the panels would not meet the relevant standards, the relevant fire safety standards. He wrote in an email, "We have to keep this very confidential." He then deliberately manipulated test data, and that just wasn't picked up by certifying bodies either. So all of those failures were compounded by a lack of scrutiny, effectively, by the relevant sort of certifying bodies. So that feeds back to that previous recommendation I mentioned about new standards for these products. The D&B contractor had an inexperienced team and just did very little to ensure that its supply chain was competent, picking up on that competency requirement, which is now a strong theme. And the building control surveyor was overworked with limited understanding of how the panels worked. So it's a very strong criticism from all of the parties involved, and you won't be surprised to hear there's some very significant litigation ongoing at the moment. I wanted to say a few words about insolvency. Cheery topic for a sunny afternoon, but sort of relevant, and so a few practical tips in this one. So 24 saw the collapse of ISG. It's one of the largest contractors in the industry, 6th largest firm in the UK in construction, revenues of about 2.2 billion, and you can see that the government was the biggest loser in all of this. They had about 1.6 billion invested in ISG. I mean, they are just one prominent example. There were, numerous larger contractors in particular who went under as well last year. That's just a key example. I mean, what can you do to protect against insolvency? I mean, obviously, it's not something you can prevent, but there are certain steps you can take to protect yourself. Before engaging a corporate entity at the outset, there's obviously an amount of financial due diligence you can do before engaging anyone, companies' house checks, credit checks, that sort of thing. Just bear in mind that the documents filed at company's house, like accounts and so on, it's only a requirement to file those once a year. So, it doesn't take long before the information is out of date. So they're very much a snapshot at that particular time. So I would say of limited value in the sort of weeks and months after those documents are filed. We're seeing in our contracts growing, increasing demands for parent company guarantees and performance bonds, but the cost of performance bonds has certainly gone up in the last 12 to 24 months. So one of the things we've seen as an alternative is increased retentions on the client side. Termination will normally almost always give you a right, certainly if you're using any kind of industry standard contract, to terminate a contract, but just be wary of making this problem worse and terminating wrongfully or too soon. The fact that a company's in trouble, there's lots of media stories and late with payments, those things in themselves generally won't trigger a termination right. You'd need to, usually the process in question, like administration, has to have formally started. So just be very scrutinize very carefully the grounds of termination if you are thinking of terminating, because if you terminate before you're entitled to, you'll be on the wrong end of a claim yourself. And then a practical point, I mean, simply just don't kick it all down the road and don't let debts accrue. There is a very rapid process in the industry for resolving payment disputes, and we've done a number of presentations on adjudication, but it is quick, and it is a means for not letting large sums rack up. Okay, on to the last two things I want to cover. I'm not covering cases in any great detail because Stephen's going to cover some current cases, but there's two from 2024 which I wanted to mention. So the Abbey Healthcare case, I'm not going to take you through the facts or anything like that, just the takeaway, which is on the slide there. So this case decided that collateral warranties are not construction contracts. What does that mean? Well, it means there isn't an implied right to adjudicate in them. So a dispute under a collateral warranty you would not be able to adjudicate. The only caveat to that is you could still have a clause in there like that brought adjudication in. You can always include it, but it certainly won't be implied. And then the last case I want to just mention is the Bellway Homes case. So you probably be aware that one of the key features of adjudication is you can only refer one dispute at a time. And it was often, it was thought that referring a dispute on a smash and grab basis and a true value basis at the same time, even though they both get you to the same end point, so they both relate to the same, underlying issue, would be two disputes. Smash and grab, very briefly, is the argument that it doesn't matter what the reasons are for withholding the money, you can't do it because your payment notice is late, or you pay less notice, or non-compliant in terms of its content, because it just doesn't explain how you've arrived at the sum due. So improper notices is the smash and grab, and then true value is looking at the underlying merits and reasons for withholding money and whether it was right to do so, and whether there were defects, etc. So two different arguments. One's written really bad paperwork and one's the underlying issues, but they both get you to the same place as I am due this money, please. But the court found in the Bellway Homes case that you can run the two arguments in the alternative. So if you have both of those claims available to you, you can run them both concurrently. So if you're lost on the smash and grab and the notice was held to be valid, the pay less notice, you could then sit back, rely on your true value arguments instead. Okay, that was a very quick wrap up of some key points from 24. I'm going to hand over to Stephen, who's going to talk about some current cases.
Thank you very much, Patrick. That was a very insightful canter through 2024 and what a year it was. Good afternoon, all. I'm Stephen Williams, and I'm an associate here at Burkitt's in the construction engineering team. And this afternoon, I'll be talking to you about some interesting case law impacting the sector. So this morning I'll be talking about three cases. First is the case of Darcliffe, and it's all about establishing a proper cause of action in the context of a £7.5 million loss involving ground dissolution on a site. The second case is BDW and Ardmore, which is about claims being adjudicated under the Defective Premises Act, and this is a rather big change and is probably going to increase the scope of adjudications. And the case of Tophausen and Rolls-Royce, which is about the interpretation of a cap on liability and how that cap applies, and whether interest for late payment is included within the scope of the cap or in addition. So then, the first case, Darcliffe and Glanville Consultants. Let's go through the facts here. So Glanville were engaged to carry out a desktop report on the ground conditions of a site of a potential development in 2014. Glanville subsequently produced a second report, which was in similar terms to the first report. And further to Glanville's reports, Ground and Water Limited were engaged to carry out an intrusive site investigation in 2017 and 18. I should just say that the proceedings with Ground and Water Limited were settled, so they don't feature any further. On the back of those reports, Darcliffe purchased the site, but later discovered that it was at high risk of ground dissolution due to the presence of chalk under the site, which hadn't been flagged in the report. There was a mention of low risk, but it transpired to be quite high risk. So Darcliffe subsequently issued a claim against Glanville and GDW for damages for a whopping sum of 7.5 million for losses it incurred as a result of that widespread ground dissolution. So if we go over to the next slide, let's have a look at how the court viewed this. So the judge found that there had been a breach of duty by Glanville because the data analysed, showed that there's 5 other sites nearby showing that there'd been ground dissolution, but this hadn't been flagged in the report. And despite this, the court found that what the reports did in fact do was show a clean bill of health in respect of a geo-environmental perspective, which in reality was not the case. So the court had to consider 3 questions in order to establish causation. So looking at the question, is Glanville liable? They asked, were they in breach, and if so, what's the minimum action they could have done to cure that breach? And also, if they were, if they'd taken that step, would Darcliffe's corporate mind have been affected? I.e., would those reading the report have felt differently about its conclusions? And the corporate mind is the directors in reality. And if that corporate mind was so affected, would they have done anything differently? So with respect to the first point, the court found that yes, Glanville had fallen below the standards, and there were points that they should have mentioned. There should have been a single line warning about the high risk of ground dissolution, bearing in mind the data that was available. However, on points 2 and 3, the judge was not satisfied that Darcliffe had established reliance, and therefore they couldn't, properly said to have caused that loss. So the claim was dismissed. So based on that, then, what are the takeaways? Well, in respect of developers getting these reports, the message is simple. Don't skim read your surveys. It came out in cross-examination that the directors had skim read the reports and not read them in detail. So don't skip over the reports and record any concerns that you have in writing, because what you're really showing there is that you're relying on the report and you're taking these points seriously. And ask any questions about the data, interrogate any particular areas of concerns, and make sure you're requesting the CVs of any individuals producing the reports to ensure that they're the right person doing the job with the correct expertise. And remember, low risk was flagged here, and low risk isn't no risk. So do query those points if you see low risks, just to make sure that you're satisfied that you fully understand any implications. In respect of consultants and experts, which is probably more relevant for the people on the call today, properly review any data that you're using to produce your survey and record any method that you're using to reach your conclusions. And any risk that you notice, no matter how small, make sure you're flagging those. A failure to do so is a surefire way to ensure that a negligence allegation may come your way. And for organisations, ensure that any individuals producing reports and those peer reviewing properly understands the purpose upon the basis upon which the report's being produced, what's the purpose for it, and that those producing and reviewing have the relevant skill, knowledge and experience to understand what risk needs to be flagged and in the relevant circumstances. So go over to our next case of today then, BDW and Trading and Ardmore. So this is all about the claims being brought under the Defective Premises Act, under the DPA. So looking at the background here then, Basingstoke Property Company engaged Ardmore to design and build an apartment block in Hampshire in 2002. And following completion in 2004, Basingstoke assigned its rights and interests under the contract to BDW. So fast forward 20 years in 2024, BDW referred a claim for fire safety defects to adjudication, and the adjudicator found that Ardmore was in breach of the contract and its obligations under the Defective Premises Act and awarded BDW over 14 million. So Ardmore refused to pay, and enforcement proceedings were therefore commenced by BDW. And Ardmore resisted those proceedings, resisted enforcement on various grounds. So most notably, that there was a lack of jurisdiction, and this is because a claim was made under the Defective Premises Act, which was not within the scope of the contractual limitation period. The Defective Premises Act has an extended scope for claims, which is 30 years, and that has always been the understood position, that you can't bring claims and adjudications under the Defective Premises Act. So could perfectly understand why that ground was raised in resisting the enforcement. The second most prominent point was a breach of natural justice, and it was argued there is an inherent unfairness because of the time that's elapsed since the works had taken place. PC was over 20 years ago here, so I can understand that position too. Because documents, etc., are more difficult to obtain and people have left the business. However, the court dismissed those arguments and nevertheless enforced the adjudicator's decision. So what are the takeaways from this then? Well, given that the scope for adjudication claims is extended, the Defective Premises Act claims can be brought. I think there's now going to be an increased difficulty with obtaining records and evidence owing to the 30-year limitation period. Very often documents and data won't be available and people have left the business. So that's going to be a real challenge. And as a result of that, I think there's a real potential that case law will develop, which sets out, the circumstances in which natural justice arguments will succeed. In this case, it didn't, but I think there will be circumstances where it's, deemed by the court, unfair and you can't properly defend yourself given the lapse of time. So I would suggest that you review older projects and carefully consider, proactively what's missing, what you have, and reach out to people if other people that may have documents, such as project managers or others involved in the project. So that's all I have to say about BDW for now. It's a very important decision, and we'll see how it pans out, in the coming months and year, because it is a decision that has been appealed. It's potentially on unsteady ground, so let's see what happens. We'll watch this space. I'll canter through the last case for the day because I know we've got some questions and I'm keen to get back to the Q&A session myself. But this is the case of Tophausen and Rolls-Royce, and all about the applicability of a liability cap. So in terms of the background then, Rolls-Royce were engaged by Tophausen to design and maintain a digital visualization software. And following delays and various disputes, Rolls-Royce terminated the agreement. The agreement itself included a provision which provided that the total liability of either party was limited in the aggregate, no matter how arising, to the amount of 5 million euros. But elsewhere under the agreement, it was provided that interest was payable as a substantial remedy and the sole remedy for late payment. So in the first instance, it was held that Rolls-Royce were entitled to 8 million in termination damages, less the 800,000 owing to Tophausen. After applying the liability cap, the court found that 5 million plus interest was owing to Rolls-Royce. Tophausen was unhappy about how that was applied, so they argued on appeal that the basis of the set-off should be after the liability cap, not before, and said that the liability of the liability cause is the total liability of either party, and it's not a net liability considering all the claims. And the court accepted those arguments and found that yes, that is how the liability cap should apply here, and damages were therefore reduced to 4.2 million, which was the in favour of Rolls-Royce, which is the 5 million less the 800,000 euros owing to Tophausen. Tophausen also tried to argue that interest should be included within the liability cap, but the court wasn't having that argument. It said that interest was a sole and substantial remedy, and the clause, if it was supposed to include interest, should have said so. So what are our takeaways here then? Well, first and foremost, this is good advice for any drafting really, but give careful consideration to the purpose of any contractual clause and how it might be interpreted, because it may have an opposite effect or not the same effect as you originally think. So carefully consider clauses, but in particular with liability caps following this case, think through how the cap will apply, how you want it to apply, because clearly in this case the parties had very different views when it came to litigating. And if you prefer one approach, make sure your agreement expressly says that. Otherwise, it won't apply. And an interest is an incentive for timely payment, and it accrues separately to any caps on liability. And if you wish to override that, then once again, your interest clause needs to expressly state that. Okay, that's all from me for now, but I'll hand you back to Stefan to lead the Q&A session. Thanks, folks.
Thank you, Stephen. Thank you, speakers. Okay, so we've got a bit of time left now to do some Q&A. We've had some questions come through during the course of the session, so thank you very much for those. I'll crack on then. So, Patrick, I'll come to you first. Question related to the Building Safety Act legislation. What is the difference between health and safety / O&M files and the golden thread?
Okay, well, they're three sort of separate documents, although the health and safety file and the golden thread are linked. So the health and safety file, that is a requirement of the CDM regulations, the construction design and management regulations, which is something that the principal designer must prepare. CDM coordinator in old speak, and that is a file which makes sure that all health and safety risks are recorded and shared, and everyone's made aware of them. So it's very much relevant to sort of fire safety, but it comes from the CDM regs. O&M manuals, operation and maintenance manuals, they are more practical documents around how a building is operated, or our system must be operated and maintained, in instruction manuals to in very sort of basic summary. And then the golden thread is a new requirement from the Building Safety Act, and it only relates to higher risk buildings. And that's the duty to maintain all of the sort of core information around understanding a building's design and construction, so all of its fire safety risks can be understood. So there is quite a link between the sort of CDM health and safety file and the golden thread, in that they are both, their purpose is to minimize fire safety risks, but the golden thread requirement is more onerous, I would say, and it only applies to HRBs.
Good stuff. Thank you, Patrick. I will go to George next. Question here for you, George, about sort of contradictory aspects of a contract. So where there's a contradiction between a requirement for new materials in a contract, but the drawings or specifications show something like reclaimed timber, for example, what would take precedence?
So this is really going to depend on the contractual terms between the parties. So ideally, what you will have is an order of precedence clause where you're clearly setting out which of those two terms is going to take priority. I mean, ideally, you won't have the discrepant terms. If you do, order of priority would be the first place to go to. Now, if you don't have that, most standard form contracts will have that structure in place for addressing discrepancies and ambiguities. So JCT has a structure along those lines. NEC, you also have the obligation to notify project managers, who will then issue a instruction to deal with the ambiguity. Of course, that all depends on on the contractor and the parties actually using those clauses, noticing the discrepancy and dealing with it promptly. In the absence of any of that, if we do reach a point where we're actually having an argument over what's ended up in the final build after the event, then there's no real clear answer to which of those contradictory clauses would win out. You really fall back to sort of typical approaches of contractual interpretation, discrepant clause interpretation. The courts will look at it, they'll think about what was the intent of the parties and what's the fairest resolution. So they'll think about things like what is the most specific and bespoke requirement of the two, and in that regard, the very specific specification of certain materials may well win out in that conversation. But it's really going to depend entirely on the contract the parties have entered.
Good stuff. Thank you, George. Stephen, question here for you about professional negligence with consultants. So if producing a report which is wrong is not enough to bring a claim, when will a consultant be liable for preparing a negligent report?
Yeah, very good question. I mean, the important point to consider is there are various elements for bringing a claim that you need to make in order to be successful. So that any claimant must demonstrate four things. So the first is that the defendant owes a duty, in this case a duty to provide a report with reasonable skill and care, judged by the standards of a reasonably competent consultant carrying out that role. And secondly, the defendant breached that duty, so failed to produce the report to the required standard, and that thirdly and fourthly, there's been a loss that's been caused by the defendant, and causation is a crucial element here, as we saw in that case, in the Darcliffe case. And if you can't establish causation, it doesn't matter that there's been a report that's been produced negligently. Your claim won't succeed. A more obvious example of this is say a developer looking to buy some land, and they commission a report before doing so, and that highlights a number of things, but actually the recipient never looked at it anyway. They shoved it in a drawer, but then goes on to suffer a loss after buying the land. Well, even if that report was produced competently, it wouldn't have made any difference at all because they didn't read the report. So yeah, I mean, properly read your reports, but to establish a claim, there's four components: duty, breach, loss, and causation. Those are the important tenets. And if you're facing any claims, or you're looking to make any, it's recommended always to take early advice.
Good stuff. Thank you, Stephen. I'll move on quickly just to try and squeeze in as many questions as we can. Patrick, I'll come back to you. Question about adjudication. So is the option of smash and grab and true value in the same adjudication only available to the referring party? Or in other words, the responding party must still start a separate true value adjudication if they lose a smash and grab?
Well, the answer to both of those is yes, in effect. So just running it through, if you're it's the claimant, the referring party would raise the two arguments. I'm owed the money because of the smash and grab, because of the improper notices, late pay less notice, and if I fail, or if I fail on that, then I'm due the money on a true value basis because the works aren't truly defective, or too much money has been withheld, whatever it may be. So the referring party would run the two arguments in tandem. You don't have to, of course, if you're much cheaper to run a smash and grab on its own, because it's merely about the paperwork not having been served on time. But if you were a bit shaky on that, or you just wanted to be absolutely belt and braces, you'd run both. So as the defendant or responding party, you'd respond to both. And then if you were the responding party and you lost on the smash and grab element, you could still try and recover it in a future adjudication on a true value basis.
Good stuff. Thank you, Patrick. Okay, time for one more. George, I'll come back to you. Does the MTH, does the Højgaard and Eon case decision contradict the principle of, or bit of Latin for you, contra proferentum?
So, for those who don't know, contra proferentum is this assumption, setting all else aside, that the person who's actually drafted the contract should be the person who's prejudiced as a result of those terms being inconsistent with each other. I would be very surprised, and I haven't recently read the pleadings, but I would be very surprised if Højgaard didn't refer to this somewhere in their defense. Generally speaking, when it comes to complex construction contracts, you'll see this principle applied or used quite infrequently, and that's because the courts tend to take quite a dim view where it comes to commercially astute parties, technically astute parties who fully understand the contract they're entering into, will have really looked into or perhaps even contributed to putting together those contract documents. There tends to be a preference to not assume that one party has taken the lead and dominated the contract drafting in that way. The other thing probably worth mentioning around Højgaard is the core issue, despite the fact there was a discrepancy between the J101 standard and the design life of 20 years requirement. The issue with J101, that the design specification that they'd asked for, the issue there was actually with the technical document. So you're almost going one further step removed from E.ON's actual drafting themselves. And to that extent, although it feels quite unfair to hold Højgaard to that kind of standard, you could also make a case it'd be equally unfair to also punish E.ON for that contradiction that came up in somebody else's documents.
Great stuff. Okay, thank you, George. That's just about all we've got time for. We almost managed to keep to time. I hope you managed to get something out of that. I hope you found the session informative and useful. If you've got any feedback for us on the session, we're always really pleased to hear that. So please do send anything like that through to the CICES team, and that will get passed on, in particular in regards to anything you might want to hear about on different subject matter in the future. Thanks again to the CICES team for inviting us to deliver the session this afternoon. Thank you once again for joining us. Have a good day, and we hope to see you next time.